Thank you. That was a great setup. Welcome to this panel. I want to thank the organizers and the staff for this great day and great project, and for giving me a chance to participate. So our panelists today are Alan Chen, who is Thompson G. Marsh Alumni Professor at the University of Denver Sturm College of Law, Jamal Greene, who is here at Columbia as Dwight Professor of Law, and Amanda Shanor, Assistant Professor at the University of Pennsylvania's Wharton School. I want to say just a couple of preliminary comments, and I'm also going to do something a little different from what happened this morning, because I'm going to give a few broad suggestions for things that the authors should consider in doing the revisions, because we're working with drafts and they're offered as a hopefully constructive suggestion, but I will give them individually, one or two things before I turn to the questions. And as in the earlier panels, each person will introduce their own research. I do want to say something about the title of the panel, with respect to the organizers. And I did not say with due respect, with real respect, as opposed to that sort of halfway snarky due respect that someone sometimes uses with a judge one is annoyed with. Government lies isn't exactly what these papers are about. And so I wanted to point that out, lest those of you who are listening to our discussion find yourselves confused. Government lies, to me, is more what Helen Norton has done in some of her earlier very important work about where the government itself, as the speaker, not somebody engaged with the government or representing the government, but the government lies about things like what is going on in a war in Southeast Asia that Mark Tushnet referred to this morning, though not in identifying it, or super funds and saying they don't need to be cleaned up, or a government that might lie about the incidence of COVID. These are much more subtle problems. And in some of them, the government is the speaker. And in some of them, the question is, how can the government respond? So that said, we'll start with Alan.
Thanks, Catherine. Thank you to the Knight Institute and to Genevieve and Katie in particular, and the rest of the staff for putting this great program together. I am a little bit of an outlier on this panel, even with the broad definition of government lies. Because I think, unlike every other speaker today, I come to not to bury lies, but to praise them, and at least in a very narrow and specific context. And so the inspiration for this paper is actually comes from a case that I was litigating when I was arguing about the unconstitutionality of Kansas's ag-gag statute in the 10th Circuit early last year. And one of the judges one of the arguments I made was, if a state can prohibit lies that were used to carry out undercover investigations, and then there would be nothing stopping the government from outlawing other types of investigations, such as civil rights testing. And one of the judges on the panel looked at me and said, and I said that those are long-standing recognized lies that are permitted under the law. And the judge looked at me and said, well, those aren't First Amendment cases. And my response was, but they could have been. And so the point is that if the state can outlaw lies in the context of undercover investigations, or what I call investigative deceptions, that seems like it should be a First Amendment question across the board in terms of what the value of the lie is, and what the corresponding social harms that are caused by those lies might be. So investigative deceptions I define in the paper as intentional lies or omissions that are lies about one's identity, one's political or journalistic affiliations, and one's motivation for wanting to gain access to a private space. And I divide the paper up into different contexts. And I say in some contexts, these investigative deceptions are not only permitted under the law, but they're celebrated. And the three contexts in which I describe this are civil rights testers who frequently lie about their identity, use false information about their financial background, and their motivation, which is that they're not actually seeking an apartment, but they're trying to identify racial steering by landlords and real estate agents for the purpose of gaining access to those properties, but also for the purposes of identifying violations of civil rights laws. The second favored context that I describe are union salts. So those who are not familiar with federal labor laws, is a very common and permitted under the law for a union to send one of its employees or a volunteer working with the union to get a job with a non-unionized employer, lying about who they are, that they're not affiliated with the union, and for the purposes of getting inside the workplace and organizing the workers. That is permitted under federal labor law, and the Supreme Court has upheld and the National Labor Relations Board's sanctioning of that type of deception. And then the third context, and this is about government lies, are undercover law enforcement officers and who frequently lie to gain access to drug dens or other places where illegal conduct is being carried out in order to identify and uncover violations of the law. And in all three of these contexts, as I described in the paper, we don't view them as speech activities or speech producing activities, but they certainly could be. They all expose information that would otherwise not be available to the general public, to the public gaze. And then I contrast that with what I call the disfavored context, which in some ways I think are actually stronger cases for First Amendment protection than the three favored contexts. And that is undercover investigations by journalists who who disguise their identity in order to do a story, to gather news for their stories. And then political activists who sometimes have appropriated these strategies in order to investigate wrongdoing or what they allege to be wrongdoing on the part of other private actors. These are disfavored in a couple of different ways. In the journalism context, there are professional norms. In fact, it is largely the practice of most major media entities to forbid their reporters to engage in deception in order to carry out a story. So there's that dispute. And then there are external constraints that are from the law in the form of private tort actions against reporters who do undercover investigations for trespass, violation of the duty of loyalty, and other common law norms. From the context of political activists, they are also potentially subject to tort liability. And also in the context of animal rights investigations in many states, the states have adopted criminal laws, making it a crime to engage in this type of deception. So Alvarez, which we've talked about a lot this morning or today, says, as we've previously discussed, that the government may regulate lies unless they cause a legally cognizable harm. And the argument for prohibiting these types of undercover investigations is that these lies allow individuals to carry out activities that violate the law, common law duties of trespass, the common law duty of loyalty if it's an employment-based investigation, and in some context, an invasion of the privacy of those who are the targets of the investigation. And in my previous work, I've talked about these lies, these investigative deceptions, is what I call high value lies. That is, they actually are not only, even if to the extent they might be harmful, but they also, unlike some of the lies we talked about this morning, are actually socially productive. That is, that they are lies in the service of speech, lies in the service of being able to produce truthful speech, and lies that very much, I think, promote democracy, unlike the lies that we discussed this morning. And in my prior work, I've sort of used what Mark Tushnet calls the first order defense of these lies. That is, that they fall into these utilitarian categories of promoting democracy and the search for truth. But in this paper, I take a slightly different tack, and I adopt Robert Post's definition of social practice as a way of examining whether a particular type of communicative activity has constitutional value that contributes to in this case, the values of the First Amendment. And so I argue that we should look at all these, the favored and the disfavored contexts of undercover investigations the same way, that they all produce the same types of benefits. And to the extent that they produce any harms, like common law trespass, I argue if those harms are present in the unfavored context, why are they not examined that way in the favored context? And that's, I'm out of time.
Thank you, Alan. So I know the authors would all rather hear me tell you what I love about their papers, and all their papers are great. But as I warned, I'm going straight to the suggestions. Alan mentioned in his summary the use of trespass law as lower courts have been looking at these kinds of cases. And he notes that there's a lack of uniformity among the states in what they consider the definition of trespass, which is a criminal offense. And he notes in passing, to be fair, that there are some other constitutional rights where there are disparities depending on where you live. In other words, a floor that your rights can't fall under, but then states treat the dignity of the right differently in various contexts. And he points out contracts and procedural due process. But we also find disparities in the scope of constitutional rights in some areas that I consider much closer to the question of truth and falsehood. Most obviously, abortion. And in the First Amendment context, students' rights to their own expression vary greatly depending on the circuit where the Supreme Court has not reached the question yet, and on state legislation, where quite a few states, though not far from a majority, have enacted legislation basically saying that the most protective standard for student speech applies to all student speech controversies in the state. And California is the foremost of those, thus reaching quite a few people. So I think that requires a little bit more teasing out. And then in the First Amendment context, it struck me, one of the questions you raise is about whether the property is open to the public in terms of thinking about the speaker's right to ask these questions and do this research there. And since we're talking about the First Amendment, I wonder whether you're thinking of this primarily as a matter of property law, or if you're also trying to invoke the public forum doctrine or some variation on it. And finally, I'm going to come back to this in our general questions, but when you talk about the definition of what you think should be protected, you talk about the fact that the scope of the project should be one of the limits. You shouldn't go beyond the scope. And that leads me to wonder, for example, if somebody went in, forgive me for using this hypo, because they heard that there was a very dirty kitchen in the Pizzagate pizza parlor, and they stumbled upon some young children in a closet, are they limited, or can they go further if we're talking about the social value of the speech? Just some things to think about. Jamal.
Thank you. And I'll also give thanks to the Knight First Amendment Institute and to Katie and to Genevieve for their inspiration on this project. The paper that I submitted for this is called Government Counterspeech. And it is about maybe what it sounds like it's about, which is about how the government might respond to lies. Often when we talk about the relationship between the government and lying, we're often talking about the lies told by the government itself, or maybe we're talking about direct regulation by the government of misinformation or falsehoods. And this paper is really focused on the government's efforts to respond to lies through speech. Now, what makes, I think, this what I think makes this an interesting question is that, there is a kind of conventional wisdom that would tell us that how the government responds to lies is not a particularly interesting problem. We are endlessly informed that the appropriate response to speech that one disagrees with or that one thinks is untrue is more speech or responsive speech. So counter speech is sort of the thing that kind of sits at the core of the First Amendment. That's the right remedy when it comes to freedom of speech. This is the classic Brandeisian Millian kind of view. You give autonomous citizens the information that they need to respond and make their own judgments about what's true and what isn't true. The case that kind of has stuck with me for a long time and probably sticks with a lot of people who think about the First Amendment a lot that I want to use to complicate this is Arizona Free Enterprise Fund's Freedom Club PAC versus Bennett. In that case, that was a campaign finance case in Arizona. Arizona had a public finance scheme. Part of this public finance scheme is that if you were a participant in this scheme, you get matching state funds that increase your pot, and the amount of matching funds that you got would increase if your non-publicly financed opponent spent above a certain threshold, or if independent groups spent above that threshold on behalf of that non-publicly financed political opponent. And the majority strikes this down, Supreme Court strikes this down on the ground that that kind of triggering system constitutes a punishment of the speech of your opponent, so that the government is engaged in an act of punishing speech, I guess, political speech on the basis of its content or viewpoint. Now, there are lots of complications here, one of which or two of which really, Buckley versus Vallejo and Citizens United, which tell us that spending money on political speech is itself protected as political speech, or at least it should be treated in that way. But there are also other cases that, of course, tell us that government speech has no First Amendment limit to it at all. So here we have government engaging in political speech that is not only not unlimited, but is subject to strict scrutiny, right? So the question is sort of what gives here is the direction, the government directing resources in the direction of certain kinds of individual speech in order to counter it in some way. Is that impermissible government viewpoint discrimination and the most awful thing one can do under the First Amendment, or is it government speech, which is absolutely protected and has no limits according to the court? Now the broader issue is that if we think that the right response to lies is government counter speech, it sounds like we need to work this out in order to figure out exactly where those limits are. How far can the government direct its resources towards countering the speech that it doesn't like or disfavors in some way? Now, the suggestion is that the doctrinal gap that I'm trying to identify here arises for a couple of reasons. It arises in part because courts have continued to say, the Supreme Court has continued to say, and seems to be accelerating the instances in which it says that the government is in fact unlimited by the First Amendment in what it can or can't say. I doubt that courts really mean that, and that there's the famous New Hampshire a license plate case, Woolley versus Maynard, where that's live free or die on the license plate, and the question is, can you get an exemption from that if you don't like that particular phrase or have a religious commitment or some other commitment against it? If it said vote Democrat or die rather than live free or die, I would think that should be struck down on its face and not have to await an objection from someone who's a Republican or something like that. But there's certain kinds of speech that the government just can't engage in, and that's a First Amendment problem and not just a problem in some other constitutional domain. I think the other way in which there is a kind of doctrinal gap here is just the general unwillingness of courts, and this is of much longer standing, of being unwilling to distinguish between different kinds of viewpoint discrimination. Viewpoint discrimination on a purely partisan basis is different from viewpoint discrimination about some public health outcome or something like that. And we say that those things are really the same, but they can't really be the same. So what do you do about this? What's the right answer to this a conundrum? I offer in the paper a kind of multi-part test of when we can identify the instances in which we should be comfortable with various forms of government counterspeech and when we should not be comfortable. The multi-part test is not designed for courts as such. It's not, here's the court totality of the circumstances test that they should apply. It's designed really for citizens in trying to evaluate the behavior of the government. There are instances in which you might use what I'm about to say in litigation, but don't be deterred by the fact that it's hard for courts to apply this kind of test. But the kinds of considerations that I suggest in the paper might be relevant here include the purpose of the government speech, right? Is it just is it trying to lie itself, or is it actually trying to respond to something that it reasonably thinks is problematic or untrue. How much separation is there between the government speech and the private speech of its officials, right? So an official giving a speech is different, should be thought of as different than the government directing financial resources or subsidizing something. The degree of transparency as to who's speaking, who's responding, who's getting out there and putting speech into the world, and the governments of various kinds have had problems along this line in the past. I suggest that there are very good reasons government should be transparent when it speaks, and those reasons are stronger as to government speech than as to disclosure requirements for private individuals. The availability of alternatives, right? One of the reasons we worry about government speech in general is that it might be able to monopolize or have excess power within the kind of speech marketplace. And so we should rightly pay attention to that in this context as well. Are there electoral implications, right? So I think part of what's really happening in the Arizona case is a worry that this is interference in an election and directing speech towards a favored candidate in an election, something that as a constitutional matter, there actually isn't much, firm constitutional ground for saying that the government can't do that. But we all think that it probably shouldn't be able to do that. So I think that's probably partly what's motivating the court in the Arizona case. And the last factor I mentioned is what I call the generality of speech, which is, are we talking about the government responding to evidence or responding to information? Or are we talking about the government engaged in some kind of ad hominem or calling out a particular identity group or something along those lines? And I suggest in the paper that there are a variety of reasons we should think that that's more problematic and something that government should be less able to do. So I'll stop there and look forward to the discussion.
Thank you, Jamal. So let's start with the distinction that you draw between the individuals who are government officials at any level and the government itself. So I understand this paper to be directed at what the government itself says, but I'm not sure that distinction is drawn out quite as clearly as perhaps it might be, because you go into some discussion of the speech rights of public employees, but you don't so much give examples of when the government as such is speaking and how we know the difference. And I would also suggest that the public employees may not have as much right to speak in a way that differs from the government position, even on a matter of public concern, as your paper suggests in its very brief discussion. Because to the extent that the speech they engage in as citizens overlaps with something in the scope of their employment, which the court has defined very, very broadly, their rights are quite constricted. So I just suggest you dig a little deeper into that. I'm also interested that you sort of say that this is too complicated for the courts to determine, and therefore we should leave this to some form of social enforcement, which is very much related to some of the conversation in the first panel this morning, and certainly has a place. But we're living in a time where we see the limits of social norms that have no stronger enforcement. And I think your factors are very helpful and a really good step. And courts look at the totality of the circumstances all the time in all kinds of contexts. So I question why you so quickly conclude or concede perhaps that you don't see this as something for judicial enforcement. So building out public morality without judicial review puts a limit on how powerfully your limits could be themselves accomplished. And finally, and perhaps my biggest question, is that at a certain point you say that we shouldn't, or the government should not have certain speech that it regards as disfavored. And of course, there is some viewpoint concern there, there's some discrimination concern there. But the whole enterprise is about counter speech to speech that is just logically disfavored. Why would the government be engaging in counter speech if it hadn't already identified the original statement as one it disfavors, whether because it's not true or because it undermines important social policies? And as you point out, sometimes it's hard to distinguish the governmental needs to have efficiency, educate people, accomplish its policies from just politics and policy distinctions. But I think all of this could also very usefully be sorted out a bit more. But thank you. It's a very interesting contribution. And this brings us to Amanda.
Hi, you all.
Thank you.
Okay, I'll try to sit up close. So thank you all so much for coming. It is really a delight to be here with you all, with such superb scholars across the board. And also thank you tonight for bringing together, I think, like a set of questions and set of people that are really pressing today. So in my paper, Outlaw the Big Lie, I consider what I think to be one of the most important and most dangerous lies in recent history, namely the allegation by former President Donald Trump that the 2020 election was stolen from him by Joe Biden. Despite, I think, pretty widespread recognition that the big lie fueled the storming of the US Capitol and that it may cause violence and election subversion going forward, conventional wisdom holds that the First Amendment prohibits lawmakers and counsels against private media companies from doing anything about it, or at least not much. In a nutshell, in this paper, I argue that that assumption is incorrect. Public and private actors alike should actively combat the spread of the big lie and other intentional lies about the factual outcomes of elections. That's actually a really narrow band, but I think it's an important one. Doing so, I argue in this paper, will advance the First Amendment's deepest democratic values. The motivation for writing this paper, to be honest, is grounded in a real serious fear about the fragility of American democracy and the rise of authoritarianism around the world. Okay, so in my tiny bit of time, I'm going to hit two things. One, what's the big lie? A little bit of history about it in very brief context. And then two, what's my argument? Also brief context. Okay. So as hopefully some of you know, Joe Biden decisively won the 2020 presidential election, but Trump refused to accept his loss. For the first time in American history, the losing presidential candidate refused to concede. Instead, he basically alleged massive voter fraud in all caps and denounced the election as stolen and the greatest crime in history. Trump's false claims have proven profoundly, strikingly effective. Polling since 2020 has consistently found that roughly 75% of Republicans believe that the 2020 election was stolen. The January 6th insurrection and violent attack on the Capitol, I think, reflected that belief. And in response to the big lie and the belief of Republican constituents in it, state lawmakers across the country have introduced hundreds of voting restriction bills, including laws that limit voting, time, place, purging voter rolls, expanding voter ID requirements, and I think really important, an increase of partisan influence over elections. They have filled key election oversight jobs with partisan supporters. Putting the big lie in brief historical context, like lies in politics are as old as politics, maybe older, but the tactics of the big lie also have sort of like a particularly long and important lineage. Many authoritarian and fascist leaders, particularly actually in democratic countries that then become less democratic, have pursued propaganda strategies that manipulate a dominant group's feelings or fears of loss and loss of power into a sense of aggrieved victimhood. Most prominently, you can think of the Nazis, of course, but more contemporary leaders, of course, somebody like Vladimir Putin or Hungary's Viktor Orban. The big lie exploits similar dynamics in the American context. Trump speaks to the loss of status felt by white Christian conservatives, particularly men, and casts them at the victims of a morally corrupt liberal globalists who have made them the victims of the greatest election fraud of all time. Okay, but so why now, right? It's not like we haven't had demagogues before, but why do so many people in the United States believe this lie? I want to highlight just a couple reasons. We no longer have the 5 broadcast news channels that create a space of shared belief about facts in the world, including about election outcomes and really the value of democracy itself. Much like the atomization that industrialized capitalism right before World War II, 20th century information capitalism, I suggest, has produced an even more atomized society, now separated by filter bubbles based upon identity affirming content, curated to increase user engagement and platform profits. So in addition, we see at least a little bit of sort of like reduction, I'm going to say, of white supremacy, which again fuels, it's that fear of loss that Trump has really capitalized and weaponized. Election law scholar Rick Hasson has warned that the fallout from the 2020 election may, he says, have served as a dress rehearsal for a future coup. Okay, so, but despite this, governments and media companies have been hesitant to do anything. And I think part of why is a really big misconception about the First Amendment. Okay, I have very little time, but I'm going to tell you why. So it's true, as we've been talking about, that the First Amendment, protects a lot of political lies, a lot of political misstatements of fact. My argument is that intentional lies about the factual outcome of elections fall outside of that rule. The First Amendment permits laws about the inputs of elections, like when or where you vote, to be regulated for falsity. And my argument here is it should also permit the regulation of the outputs of elections. Okay, so the First Amendment also, in many contexts of what I consider informational reliance, where people depend on the information provided by someone else, the First Amendment oftentimes permits regulation for truth. So you can think of things like fiduciary duties or fraud or malpractice or contracts or perjury. All of those involve a type of informational dependence and can be regulated for falsity. Okay, so I think the same should be true for at least this tiny band of the factual outcome of elections. Why? On almost any account, self-governance is a preeminent commitment of the First Amendment. And shared belief about the outcomes of elections are really like at the existential point of what you need for democracy, to have peaceful transfer of power, to have public perception of electoral integrity, and to have any form of democratic legitimacy. So I think that goes to the very core of the First Amendment's purpose. And for that reason, I think that public and private actors alike should outlaw the big lie.
Terrific. I can't believe you summarized the paper so quickly. Thank you. Okay. I think your statement about the conventional wisdom that the First Amendment prevents lawmakers from doing anything about these kinds of lies after the fact is generally accurate, but perhaps a little overstated, because anything is too strong. If you look at the 16 states that still have laws on the books purporting to regulate lies during electoral campaigns, and the statutes that have been overturned, they are plagued by the drafters' clear failure to pay any attention at all to the requirements of the First Amendment. They are full of statements like any lies by any person about factors that could influence a vote. They're dramatically overbroad. They're also dramatically under-inclusive. And they have usually no intent or knowledge requirements. So the question remains, could someone draft a statute that might survive? And I'll be a little self-indulgent here to say, I put the final changes on my most recent book, which came out just 3 months ago, A Right to Lie, Presidents, Other Liars, and the First Amendment. I did my final changes in May of 2021, just days before the Republicans backed out of doing a joint inquiry into the events of January 6th. And I had proposed a solution to presidential lies and lies by high public officials that involved the separation of powers. And since that time, what we've witnessed about the tenacity of the big lie, which I had also agreed must meet the Alvarez requirement of harm, if anything would, it convinced me that we really ought to dig a little deeper for solutions. And like you, I've been thinking about what the government can do. And just very briefly here, I worked with the state of Washington, with the governor and a Senate Democrat, to draft a statute that tried to consider all the free speech options, and that depending on a court and how certain things were defined, I thought might survive judicial review. And I'll be talking about that at the Free Expression Scholars Conference at Yale in 3 weeks. So I'm not going to try to hijack this panel, but just to say that, those of you familiar with my work and my adamant support of First Amendment principles might be surprised that I have this agreement with Amanda. And I really respect the enterprise that you're engaged in. So I'm going to, again, just suggest a couple of things you might want to look at further. First, the distinction between the public and private actors isn't entirely clear in some of your suggestions, because there are a whole bunch of different kinds of private actors you identify. And then you suggest, but very briefly, almost in passing, that people, even a private actor, might be treated differently depending on where they were speaking. So you use the example of your friend Ben, who might be Ben W. I don't know.
Yes, he was unable to be here. He said his ears would be burning during my panel.
Okay, well, his dad is a good friend and former mentor of mine. So I guessed it right away. Not well disguised, but I guess it wasn't intended to be. So you say Ben is a private actor when he speaks in a bar because nobody's going to rely on him. So first of all, what if Ben isn't Ben W., but rather, Ben, a famous actor, Ben Affleck? Somebody in the bar might film it on their phone and put it out there where it spreads to millions of people who might think Ben Affleck knows what he's talking about. Similarly, you say that Ben might be treated differently if he's not in the bar, but rather speaking as an important person representing the ACLU. So I think it's not as rich as it could be to simply say private speakers versus public speakers. Similarly, you talk about Rachel Maddow. If she tells a lie on her news broadcast under this statutory scheme that Amanda's come up with, which would provide a private right of action to sue, comparable perhaps to defamation and modeled on defamation to some extent, saying, I relied on this lie about the election. I'm going to come back to the reliance in a minute. But is Maddow the person who would be sued, or is it MSNBC? And how is MSNBC different from Facebook? And in the context of news, could Maddow be sued if she broadcast the lie that Ben Affleck told in the bar, that was captured on someone's phone, and failed to identify it clearly as a falsehood about the outcome of the election? So I think this could be so much richer if you can work through some of these things. So that brings me actually to the first question. So instead of including this in comments, I'm going to ask you about the reliance aspect. And how would one establish that someone who was bringing the lawsuit relied on? Does that mean that I voted differently in the next election, or I decided I would never vote again? That's kind of a hard thing to prove because it's speculative and in the future. Can you address how we would tease that out? Because as Mark so correctly said this morning, the devil's in the details.
Right. So thank you for that, for the comments and also for the question. My idea of reliance really comes from what the case law already is, right? We see in a bunch of contexts like fiduciary duties or contracts or commercial speech or perjury, where at a wholesale, not a retail level, the First Amendment assumes that there could and might be significant amounts of reliance, and therefore those statements can be regulated for falsity. So let's talk about perjury, for example. You don't ask, does the First Amendment apply to protect me if I perjure myself in the court? Normally, there's not a First Amendment question there normally, right? Mm-hmm. We say instead at like an institution, I don't know, I'm going to say social sphere level, that we think that there is a likelihood of reliance, and therefore the First Amendment is not gonna interfere with a regulation for falsity. And so I think the idea here is we need something similar with regard to election falsehoods. And it would have to look like, I think, something kind of like the public figure doctrine, which would mean that we would kind of, have to path it out. But I don't think that that means it can't be done. We already do it in like dozens of contexts.
Yeah, I actually surmised that we were treating democracy itself or elections and their legitimacy as a public figure,
Yeah.
even more important than any of the public figures who are individuals.
Yeah, but I think the idea, I mean, on the last panel, right, Mark's point, like not this government, but government in general, the point here is really sort of like not about, this government or this democracy or this election, but instead the idea of democracy itself, I think, is really at the core of what.
Thanks. Alan, Jamal, would either of you like to pitch in?
So I do have a question for Amanda. I don't know if that's the style of
it's fine.
pitching that, which is, I guess my concern here is about whether this standard would have applied to Trump himself during the election, insofar as, so when we talk about intent, are we talking about what kind of mens rea do we mean here, right? Are we talking about a heightened standard, as you might wish to have, about whether this is an intentional lie as opposed to an indifference to the truth, which are of course different. The kinds of statements that we're talking about are not statements like in fact, Joe Biden's victory was not certified by such and such state. It was, I believe that there's uncovered fraud, and if you give me more time, I'm going to find it. Doesn't sound like an intentional lie, at least the sort of thing that the law can very easily define and tease out, as opposed to just a conspiracy theory, which is really just kind of not sufficient attention to evidence and facts, and not really carrying the direction in which they point, but also not provably, telling a deception. I'm sort of wondering how you bridge that.
Right. So how to implement it, of course, is a huge question. I think that I'm trying to sort of like kick off a conversation, but this is what I think about it, is that I think a heightened standard is probably advisable. I don't think it's necessarily constitutionally required. But I do think that it's just like we wouldn't think there would be a heightened standard for the idea the election is on, Thursday or whatever. But I think it's advisable. I also think that my proposal is not going to reach a bunch of the worst types of lies that cause the worst types of problems, but that's because that's not why I'm creating the rule. I'm looking at what I think the First Amendment would tolerate. And so I think, for example, for your Trump example, I don't think until like all of the voter fraud cases were actually kicked out of court could you potentially go after Trump. But once you have, a judicial decision about there not being fraud in the election, it seems like under pretty much any standard, he knows or is reckless with regard to knowing that he didn't win the election and that there wasn't fraud. Right? I mean, there's even more in his case, like, a bazillion advisors told him that there was no fraud. But I think at least that, because we have to decide on some institutional arbiter of some things about fact. And we already do that with actual elections. Like those courts were actually deciding those, underlying fraud claims. After that, it seems like, why could they not also say, you can't have him going around saying, I won the election when he didn't, or it was fraudulent when it has been found not to be.
Okay, thank you. Alan,
Yeah, I just have it's more of a comment, but I like the idea of the wholesale harm versus retail harm. But I think that the thing about retail harm is, and this sort of goes to this morning's panelists too, I think it's easier to make the argument that I showed up on Wednesday and then therefore I did not vote, than it is to show our democracy is at stake, right? And I think the problem is under conventional First Amendment doctrine is, so how is the government supposed to defend the constitutionality of the statute by showing the stakes are high, but I can't really show you, right? And so that seems the wholesale harm is like worse, but also harder to prove. this is something that Helen's written about, is the distinction between second party harm and third party harm. The second party harm is the person who's directly lied to. The third party harm is the broader societal concern.
The wholesale arm might also raise some of the same problems or similar problems to the Texas abortion statute in terms of what is the interest of the person who is coming in as a private person to enforce it under the statute you have in mind.
If there's not some kind of
there's
harm
some
to
type
that
of
actual
personal
person.
Thing
Right,
that creates
but-
some form of standing.
Right. So, I mean, in the regulatory context, again, we wouldn't ask that type of question about, you know, we wouldn't have to show reliance. Like if you tell me the election is on Thursday and I still vote on Tuesday, the government can still outlaw that. Now, that's a different question of if we're talking about a private cause of action, and I admit there might be standing problems. We can go into that. Okay, this is like not an in the weeds proposal. This is like a basic, you know, argument about constitutional values and what it might mean. But I do think that, you know, I agree that there are questions, but I don't think that they're that big, as long as we can have some kind of institutional adjudication of what the fact is. And I'll say, I don't trust courts at all these days. So I don't like this proposal in many reasons, but I do think we're in a bigger heap of trouble if we think that courts are just not going to be able to decide any types of factual outcomes in a nonpartisan way, because then like the ship has sailed as to my, you know, democracy threat concern.
Yeah. Thank you. So I'm going to move on and raise a question for Alan. And again, everybody should pitch in if you want to. So Alan, implicit in your proposal is the notion that the promulgation of information generally promotes First Amendment values and informed discourse. And you say that one of the things courts might consider, or one of the boundaries around what you're proposing, is that inquiries into matters of public concern should be favored only if the information is truthful. And then we have this kind of missing link. Who determines what's truthful and how? And this brings us back to some of the discussion in the second panel this morning.
It's a great question. So I think what I was trying to argue in that part, that limitation on the constitutional privilege that I'm arguing for, is that you can't use as a defense that you're gathering information and then report it untruthfully. So you doctor a video that you've recorded, or you lie about what you actually heard or observed. That's a sort of that you lose the privilege at that point. So and because the whole point is that so one of the things I argue is that what the courts have done so far in these cases is they argue that there's a discrete lie, which is I am not affiliated with the union, or I'm not affiliated with an animal rights group, or I'm not affiliated with an anti-abortion group. And that the harm is the access to the property gained by that, because you are getting consent, which in some states, in many states, is vitiated by deception, right? But not in all states. And so, and I argue that you should look at not just that discrete act, but the entire practice, which includes gathering newsworthy information of a public concern and then publishing it with the intent to publish it truthfully.
So
that it's not distorted. Yeah.
Following up just a little bit, in the law enforcement context, you distinguish between saying I'm an undercover agent, in other words, I'm a drug user,
Right.
and something like abscam, where government agents really induce or encourage legal acts, or at least are alleged to. So would the truthfulness in these private inquiries for matters of public concern be limited to, you can lie about who you are and your motive? Or would it go further and cover something like Project Veritas, setting up a person to not lying about what happened, but sort of making it happen?
Right. And I think my answer, my fast answer to that is that we might look at that the same way we look at the distinction between an undercover law enforcement operator sting and entrapment. Right, that we might use the same legal principles that distinguish.
But entrapment is a pretty high standard.
It is. Yeah.
Okay, I just want to make sure we're on the same page. Thank you. Other reactions to that?
So I'm sort of curious about this line drawing as well, and I'm trying to think this through. And I think one of the things I was thinking about in particular is the ethical norms of journalists, which you mentioned. And I have a sense, and this may just be idiosyncratic to me, but I have a sense that third parties or other people don't necessarily recognize those ethical norms in the same way that journalists do themselves. So in the sense that if a journalist in fact uncovers something that is true, that they did not induce themselves, and that is genuinely in the public interest or unambiguously in the public interest, and most of us don't think it's particularly problematic that the journalist might have engaged in deception. I mean, again, this may be just my sense, but I agree that many journalists would say we shouldn't do this, and I wonder if that is maybe anxiety on the part of journalistic organizations themselves about their role in identifying what's truly in the public interest and not private, not induced. But I do sense, and maybe you agree, that the factors here tend to be, is this something that's sort of organically true, not being induced, and genuinely in the public interest? And when we're in that space, then people generally think, well, maybe it's worth it.
Yeah, well, I think that's interesting that you make the distinction between what the general public might perceive and what the journalists might perceive themselves. And sort of that's part of my argument that as a society, I think, at least in the first three contexts, the favored context, that I think they are widely accepted. And in some ways, you could actually say like the government lie, the undercover law enforcement, is actually the most problematic, because you could argue that it's an abuse of governmental power. But it's true that I would say the vast majority of journalists I've spoken to in the ethical codes that I've read have an almost absolute ban on deception, and with the caveat, unless you can't get the information any other way, which of course is almost always going to be the case in some of these circumstances. So in some senses, the journalistic norms are actually more conservative than I think the broader social norms are, and that may be another thing that I found in my research is these investigations really started slowing down after the Food Lion case in the Fourth Circuit. And so, and some of the general counsels I've spoken to at newspapers said, yeah, Food Lion was it for us. So so that's why there are both internal and external constraints on journalists engaging in these behaviors, even though I don't have polling data, but I think generally most people would say, oh, I'm glad we found that information out.
Well, I rely on restaurant critics, and I don't want them to have to identify
Right.
themselves. So
Can I say something quick?
Yeah,
sure. Oh, sure. I'm sorry.
So one just like little comment related is the First Amendment treats a lot of the same thing differently. Like if I lie on the street, it's different than if I lie on the stand, right? For First Amendment purposes. And so I kind of wonder, even if these things are all valuable because they bring us more truth, whether or not that's enough, particularly with regard to the law enforcement example, which I think for a number of reasons might look more like other types of contexts that will make it be different. Okay, that's first. And then second, there's like a huge question of the interaction between property and free speech here. And I would love to hear more about what you think of that, particularly as the court is rolling forward to even more staunchly protect property, including as speech. But like, for example, I mean, you talk about Cedar Point, but like, that seems like a larger trend.
Right.
Thank you.
So great questions. So I'm not sure how to answer the first question. So what is the larger truth, and how do we sort of define what that benefit is? I guess I'm going on with the argument that more information is better than less information. Is it?
That's not right. Not like that it's good to have more truth. The idea that we should treat all of these different contexts the same,
Right.
when the First Amendment oftentimes treats the same speech and with the same value differently in different contexts.
So
I'm
I think
going to
that
have to move on to ask Jamal a question, because we have
Thank
people in the audience, both here and remotely, who have questions. So Jamal, and I this is not going to be easy to answer quickly. And it brings us back again to the definition problem. You decide to talk much more broadly than about verifiable factual falsehoods, and you're talking about misrepresentations that the government wants to respond to. And I guess I wondered if you could flesh out for us. You begin by saying at the very setup, it's really hard to define what misrepresentations are. That is absolutely true. But do you have boundaries about that? And what difference would it make to your argument if you used a broader or a narrower definition?
Well, I might be able to answer that quickly, which is that I don't know that this particular intervention turns on the definition of misrepresentation, insofar as I'm really talking about government speech as well as government counter speech. So counter speech being a subset of the larger category, and I'm trying to put some limits on that larger category. Those limits don't include, is there some objective sense in which the thing the government's responding to is a misrepresentation, right? The government has to make that determination on its own. And that gets to part of the reason why the paper has some anxiety about the involvement of courts in this space, because for familiar reasons, if one believes that the action turns on some assessment of whether something is false or not, there are good reasons to think that we have to lodge that in political institutions rather than in legal institutions. And that doesn't mean we don't have norms that guide those political institutions, and so I'm trying to lay out those norms, but they have to have a certain flexibility about them. And that's really at the core of the argument.
Thank you. That was really concise and helpful. Okay, so time for questions. If you are asking a question, please be sure to turn your mic on and tell us who you are if you're not choosing to remain anonymous. Mark.
So I have two, I think, fairly quick observations. One in connection with Amanda's proposal, and it's sort of about the political economy of the suggestion.
Yeah.
And it's, by the time you get around to enacting this statute, A, you can't enact it because too many people believe the lie. And B, it's too late to do anything about it already. I come at this from all this stuff about how you deal with these terrible populists around the world. By the time they've taken power,
Yeah.
it's too late.
Yeah.
And then, of course, then if you enact it, the problem's gone away already. So it's a sort of puzzle. On the suspended context thing, Jim's. Sorry, Alan's too many Chens in the world. I wonder about the necessity point that you raised. So I've thought about it in two settings. One is the social lie setting, where people say, oh, social lies are not such a big deal. Breyer says that in Alvarez. It's just plainly wrong in Alvarez. And it's almost never necessary to tell a social lie. There's almost always a way around it. Isn't the baby big is my version of this, right? What a big baby. And similarly in the school context, the teacher who says the atom is like a solar system with the nucleus at the center, and that's not true, and the teacher knows it's not true. But it's also easy to say, look, this isn't exactly right, but as a way to get you to think about the problems, here's a way. So now in your context, the necessity point, I mean, that's the function of the necessity point. You got to try other stuff. But necessity in this context means, I think, something like if we use the other available techniques of getting this information, there'll be a marginally less effective communication of what the information is. So if we report that 3 employees describe the terrible conditions, that's going to be marginally less effective than if we take a picture of the terrible condition. Now, I don't know whether it's worth it to say, well, okay, since there'll be this marginally less effective communication, you should be allowed to get away with the misrepresentation. And I guess I want to say two other things, just because this is my obsession. I think you talk about this in the paper. There's a distinction between finding a common law violation on the ground of invasion of a trespass violation and a legislated statute, because the institutional differences between a court saying trespass and the legislature enacting a statute are pretty apparent. Okay, that's it.
Yeah. So I guess I would dispute whether whether much of the speech is only marginally more effective. I think that animal rights investigators, for example, would try to visit the sites of slaughterhouses and control concentrated animal feeding organizations, and find, as you can imagine, you would not get access to all the areas that you might want to get access to. And then the industry started responding by saying, "Oh, don't worry, you can schedule an official tour, right, of our slaughterhouse," and those turned into like these Potemkin village kind of charades. So I do think there's a significant difference. And in some of these statutes, the employees would also be criminalized if they turn over. So it's not just outside investigators who are sometimes punished under these laws. In terms of the common law interest versus a statutory determination that there's a social harm here, and most of the statutes are defended on the grounds that they advance the interest in trespass, in preventing trespass. So they are incorporating the common law interest into the legislative justification. And that's how they've also defended these laws in court. So I'm not, maybe they're different technically because they come from the common law versus statute, but they're really sort of, at least our governments have argued that they're fulfilling the same government interest. So.
Thank you for your question / comment. So I'm very aware of that sort of like political economy issue, which is why the paper is aimed at really trying to establish what First Amendment values would be, but with a tune towards what do I think that the private actor should do, or how should they think about the First Amendment? How the big media platforms and somebody like Fox thinks about what the First Amendment, requires or, should counsel, I think, and whether or not they're committed to any particular version of government, democracy or authoritarianism. Like if you think about the platforms in other parts of the world, they're committed to other forms of governance. And I think there's a big question about whether or not, if you're Facebook, you should have any care in the world for that other than profit. But my point here is I do think, for example, Facebook, they do a lot of talk about, the First Amendment and all that protection. And I think this assumption is wrong with regard to First Amendment law, but that means it counsels for different things if you're a private actor thinking about what the First Amendment or free speech value should mean for you. I also think if there was liability for somebody like Fox, even if you had a long time of talking about lies, you wouldn't have the broad spread like Yochai Binkler's work. You wouldn't have the broad spread to like my grandmother who like is not on Crazy Pants websites. She's just watching Fox News. And so I think I'm saying it would chill certain types of speech because of the possibilities of something like liability, but also really this paper is written for, Zuckerberg.
Okay. Yes. This is Eugene.
How's this? I wanted to ask Amanda about the proposal. I very much appreciate that it sort of appreciates, obviously, it's not a bill of attainder to try to go after a particular statement or ex post facto law. Going forward, it could be the left, could be the right, could be anybody. So I'm just trying to think a little bit because it's very unusual to have a situation where you're debating about something the government has done and it's actually illegal. You say civilly actionable, but what's civilly actionable could also be made criminal. To actually say something that the government has misbehaved. So just for example, you mentioned court cases, but they're not final as to the public. Let's say somebody's convicted. And if somebody says, that's all, that conviction is a lie. That person is just innocent. You know, the fact that the court has decided doesn't mean the rest of us have to go along. So I'm wondering, especially given that you're saying that a negligence standard, which is even rarer, I mean, negligence standards are allowed in libel lawsuits, but only by private figures. If anything, the New York Times v. Sullivan rule seems to say that when you're talking about the government, it's categorical protection, much less something below actual malice. So how would this play out? Let's say somebody really does think that some election was stolen, that the 2024 election, Ted Cruz wins, and it should have been Kamala Harris who won. So he says, you know, Kamala Harris really won that election. And, you know, I know that the courts have said otherwise, but they're just corrupt. You know, it's all these Republicans who are running the federal judiciary. It sounds like what you're saying is, you know, they could maybe talk a little around that, saying, I'm not saying she won the election, but I'm saying that we should think some more about it and try to. So you could do that, but just saying what you think is going to be actionable. How will that play out? Like if there is a debate going on
I think
about
the question has
Sure,
been asked.
sure, of
Thanks,
course.
Jean.
Okay, so I mean, I think in your hypothetical is actually not one to which my proposal would apply. I'm assuming that your guy is like a guy talking like you. Okay.
No, I'm sorry. On television, Rachel Maddow.
Okay. Oh, it's Rachel doing this. Okay. So I think that she has more, just like she thinks about actual malice and defamation, she should think about whether or not she on television says the election was stolen, as opposed, or like, you know, actually who won when they didn't. And I think that's a fine, tiny request as like a big difference that might make a big difference for democracy, as where, of course, she can talk about there was gerrymandering. If there wasn't gerrymandering, then this, then that, right? If there wasn't all these other things, then Stacey Abrams would have won. Okay, great. I mean, again, this is a very minor thing to say, you just can't say this person won when they didn't win. It's about whether there's any space where we all try to agree about the basic mechanics of democracy.
And you also make clear that you're not talking about opinions. She can say,
Oh, yeah,
I
she could-
still think
yeah.
there was.
I still hate it. I still think it's illegitimate. I still whatever.
What if she says, in my opinion, all those cases that ruled against
so
it
that
are
doesn't wo-
bogus?
that doesn't
he or
work.
she won. No?
That doesn't work in the defamation context. Like if I say, you know, Jones is a liar, or I think Jones is a liar, it's the same. And my inclination is that that's probably the right rule. Again, for a very narrow set of famous actors, right? Like, again, like, I mean, I love you, Eugene, but I don't think you're famous enough even for my thing. Okay. So I'm really saying it's a narrow set of actors and it's a narrow thing, but in that context, yeah, sure.
Okay, so our last question is was just erased by me on my screen by touching something. Thank you. Thank you, Madeline. Oh boy, that's why I don't use much tech. Robert Bornholtz asks, what about an anti-lying doctrine to counter First Amendment defense against prosecution for seditious conspiracy to prevent certification of the election? So the defense would be, you can't punish me for seditious conspiracy if I'm trying to, okay, clarification, the lie is a fraud to induce the state legislature to ignore the popular vote, nominate electors directly. A legislative fact normally would be found by the legislature taking sworn testimony. So can you have a doctrine that would prohibit lying in these circumstances? I'm not supposed to answer, but if they're talking about legislative testimony, then they can't perjure themselves for the classical reasons, but.
Yeah, and if they're trying to obstruct some kind, it sounds like the obstruction that happened, and there's already a statute that says you're not allowed to do that, under which a bunch of people are getting charged.
And so there would be no defense.
So there would be no defense.
Oh, I'm sorry. Deborah has a question. I didn't see her. Thanks. Oh, way in the back. Okay. Mike.
You. Thank you. I did, but it's fine. So I really just wanted to pick up on this piece because although from my own talk, right? I'm enormously sympathetic. I think incredibly harmful lie that Amanda's talking about, hugely harmful lie to democracy. But in my own head, right, I find this the most difficult question, because how do you write this law in a way that's okay, right? So one way of limiting this law is to say, writing a limited law is to say no willful lying about what you know to be false about the results of an election, right? But if you think about applying that rule to Donald Trump or a large number of people, they may genuinely actually believe that
yeah.
they are
The Capitol stormer people, I'm sure did.
100%. So,
Right.
all of this is
Yeah.
not covered. So maybe that's not the right limit. Another limit you might propose, and this is the one I sort of hear you saying, is the one that says, well, false as determined by some preset institution that we identify in advance, namely the Supreme Court, or take your pick, right? This strikes me as fabulously problematic, right, as well, for reasons that should be obvious. So what is how do you define what counts as the fact that you're right? Because so far I still don't hear it.
Okay, so I want to sidestep this question by again saying the concept here is, what should the social media companies be doing? I don't think I have to tell you a basic, tell you how to implement this, and I think it should be actual malice, or how we're going to think about this. Though I don't think the Capitol riot people could fall under this, because again, they didn't intentionally lie or didn't intentionally believe that, right? Okay, that type of, or my grandmother who watches Fox. Okay, so again, narrow, but I think that to say that basic First Amendment values mean that we can regulate both the inputs and the tiny basic factual output is something that the company should give a damn about as a First Amendment democracy protection idea, right? And so I don't think we have to have, the intricacies of a law. I don't want there to be a law, but I do think there needs to be, Fox needs to care that this is happening. And I think the First Amendment counsels that they should think it does.
Other questions from the floor? Because one of the questions didn't take much time to answer, the one posed to Jamal. We have a little more time than, okay. I'll ask the last question then. Just picking up on what you were just saying, Amanda. Leaving social media aside, could the FCC discipline Fox or MSNBC or
Yeah.
yank their license?
Yeah, I think so. Just like they could for, commercial lies.
So that's another path to possibly pursue, although they don't do much enforcement these days.
Yeah.
Okay, thank you very much. This was a great panel. I think we have a break or not?
Nope.
I'm sorry. Withdrawn. Thank you, everybody. Great job.
It's part of the difference.